Hello friends, this is Sanjay. In this video series, we will cover the interpretation of statute subject from the LLB syllabus of Chaudhary Charan Singh University or CCSU, Meerut. The syllabus is common for both the 3-year and 5-year LLB programs. The complete playlist is available on the Lawment YouTube channel. While I have covered all the topics that are specifically mentioned in the syllabus, I have also included some additional concepts and topics which are required for a better understanding of the subject and also helpful if you are preparing for any post-LLB exams like the CLAT PG, UGC NET or Judicial Services. The timestamps for the specific topics as per the syllabus are in the description below. This is part 8 and we will discuss the important principles of constitutional interpretation. The first step in interpreting the Constitution is applying the general rules. The first one is that if the words are clear and unambiguous, they must be given the full effect. This is nothing but the literal rule that we have used with all other statutes. The second one is that the Constitution must be read as a whole. This is common sense because reading only the part of the Constitution that you want and ignoring the part that you don't want is essentially misinterpretation. The third rule is that the principles of harmonious construction must be applied. This is again the same principle of harmonious construction that is applicable on all statutes. The fourth rule is that the Constitution must be interpreted in a broad and literal sense. For example, when the Constitution talks about the freedom of speech, it should be interpreted as written, spoken, printed, and also electronic versions of speech. That is, the broadest possible meaning of the term speech. The fifth rule is that the court has to infer the spirit of the Constitution from the language. The courts will use the preamble, the fundamental rights, constitutional rights, the directive principles, and the other articles to understand the real spirit and the intent behind the articles and interpret them accordingly. The sixth rule says that internal and external aids may be used for interpreting. Again, this is common sense. And the seventh rule is that the Constitution prevails over all other statutes, which means that the Constitution is the supreme law of the country and all other statutes and laws must adhere to the framework and the limits set by the Constitution. We have already discussed harmonious construction previously when discussing about the interpretation of statutes. The same principle is used while interpreting the Constitution as well. If there is an inconsistency or a conflict or a contradiction between two articles of the Constitution, then the harmonious construction approach is used. The idea is that all the articles of the Constitution must carry similar weightage and similar importance because they have been intentionally put into the document by the framers. So, one article cannot be interpreted to cancel or to nullify another article. The court will adapt or adopt the interpretation that best balances between the conflicting articles and allows both the articles to coexist. In the RMD Chamarbagwala versus Union of India case, the court resolved a conflict between the right to practice any profession under Article 19(1)(g) and the state's power to legislate on betting and gambling under Entry 34 of List 2. It interpreted these provisions harmoniously, ruling that the legislative competence of the state over gambling did not infringe on the fundamental right to practice any profession because gambling as such cannot be considered as a trade or profession under Article 19(1)(g). In the Kesavananda Bharati case, there was an apparent contradiction between the power of the Parliament to amend the Constitution under Article 368 and the basic structure of the Constitution as can be inferred from the preamble. The court again used a harmonious interpretation approach to say that the Parliament has the power to amend any part of the Constitution, but such an amendment should not alter the basic structure of the Constitution. The term Pith refers to the true nature, the true essence, or more literally, the center of something. When we look at the cross-section of a tree trunk, the centermost or the innermost part is called the pith. Substance means the most essential part of something. When the court is using the doctrine of pith and substance to interpret a statute, the court is evaluating what is the true nature of the statute and what is the real effect of the statute. When is this doctrine of pith and substance actually used? To answer this question, you have to understand the federal structure of India. The Constitution gives the power to make laws, which are the legislative powers. These legislative powers are divided between the central legislature, which is the parliament, and the state legislatures. The 7th schedule of the Constitution has 3 lists: the state list, the central list, and the concurrent list. The central legislature, that is the parliament, has the exclusive power to make laws on the subjects in the central list. The state legislatures have the power to make laws on the subjects in the state list. And both the central and state legislatures have the power to make laws on the subjects in the concurrent list. Now, what happens when the parliament passes a law on a subject in the central or the concurrent list, and that law significantly affects a subject that is listed in the state list? Or what happens when a state legislature passes a law on a subject in the state list or the concurrent list, and that law significantly affects a subject in the central list? In that case, before deciding whether the law is valid or not, the court will look at the pith and substance of the law. Because many laws or statutes may have side effects that are not the main intention of the law, but there may not be any reasonable way of preventing the side effect without affecting the actual primary purpose of the law itself. For example, the actual purpose of a cough syrup is to provide cough relief, which is its pith and substance. But the incidental effect or the side effect may be that it causes drowsiness. And there may not be any reasonable way of preventing that side effect without making the cough syrup ineffective. So, if the actual pith and substance of the law show that it is aimed at a subject that is within the powers of the respective legislature, then the side effect will not make the law invalid. In the State of Bombay versus F.N. Balsara case, the court considered the pith and substance of the Bombay Prohibition Act and determined that its main intention was to impose prohibition on alcohol, which is within the remit of the state legislature. The side effect of this act was on medicinal and toilet preparations that also contained alcohol. And these medicinal and toilet preparations containing alcohol are actually on the union list. Since this was an unintentional side effect of the act, the court held that it will not make the law invalid. The doctrine of colourable legislation is based on the principle that what cannot be done directly cannot also be done indirectly. So, a colourable legislation is a statute which is attempting to achieve something indirectly that it cannot achieve directly. For example, if the parliament wants to ban the sale of soft drinks, but if it does not have the jurisdiction to do so, then it cannot pass a law to directly ban the sale of soft drinks. So, the parliament can try to achieve this objective indirectly by passing a law that increases the tax on the ingredients used to manufacture the soft drinks. And the tax can be increased to such a high level that the soft drinks can no longer be sold at a reasonable price. Thus, the parliament has indirectly achieved something that it could not achieve directly. In 2015, the Supreme Court struck down the National Judicial Appointments Commission Act, which would have changed the process of judicial appointments in India. One of the views there was that this was a colourable legislation because the executive was indirectly trying to control judicial appointments, something that it could not do directly. Therefore, the legislation was against the concept of judicial independence. From a federal structure perspective, the doctrine of colourable legislation comes down to evaluating the jurisdiction or the competency of the legislature. If the state legislature is trying to make a law that is indirectly trying to have a significant effect on a subject that is in the central list, then it is a colourable legislation. Or if the parliament is trying to make a law that is indirectly trying to have a significant effect on a subject on the state list, then it is a colourable legislation. In the K.C. Gajapati Narayan Deo versus State of Orissa case, the court clarified that when it comes to colourable legislation, it comes down to a question of whether the legislature has the required competency or not. If the legislature lacks the competency to pass the law on a subject, then the question of the motive of the legislature does not arise at all. Suppose there was some land which did not belong to anyone, and two farmers, Bharat and Sharat, noticed that the land was vacant and both of them thought that they could make use of it. One fine day, Bharat went to take over that land, but he found that Sharat had already come there before him and had already occupied that land. So, Bharat could no longer do anything on that land because the land was already occupied. This is how the concept of occupied field works. To understand the concept of occupied field in the legal context, we have to look at how the three lists in the 7th schedule of the Constitution are structured. The central list has the subjects on which the Parliament has the jurisdiction to pass laws. The state list has the subjects on which the state legislatures can pass laws. And the concurrent list has the subjects on which both the Parliament and the state legislatures can pass laws. What if the Parliament has passed a comprehensive law on a subject in the concurrent list, and subsequently the state legislature passes a law on the same subject? So, which law should be followed? Which law takes precedence? Well, this is where the concept of occupied field comes into play. If the subjects on the concurrent list are fields, then only one law can occupy any field at any time. That is, only one law on the same aspect or the same scope of the subject can be valid at any time. If the Parliament has already passed a comprehensive law that covers all the aspects or the complete scope of any of the concurrent list subjects, then there is no more space left for the state legislature to legislate. And the central law has already occupied that field. And the state legislature should not pass a new law on the same subject. Even if they do so, it will be void. It does not matter whether there is a conflict or there is no conflict between the two laws. Once the field is occupied, there is no more space for a new law. Whether the new law is good or bad does not matter. The concept of occupied field was reiterated by the court in the state of Rajasthan versus G. Chawla case. The term residue means something that is left over or remains after the main or the important part has been used up or taken away. For example, when you burn wood, the ashes are the residue. The concept of residuary power is again connected to the 7th schedule of the Constitution, which has the three lists of subjects. The central list has subjects on which the Parliament can make laws, the state list has subjects on which the state legislature can make laws, and the concurrent list has subjects on which both can make laws. While these lists are extensive, they are not exhaustive, which means that they do not contain every subject on which legislation may be required. If the main and the important subjects are included in the three lists, then the leftover subjects are the residuary subjects. Remember, there is no such list called residuary list. It is just a group of subjects that are called residuary subjects. So, this is not a group by inclusion. This is a group by exclusion. That is, if a subject is excluded from the three lists, then it can be considered to be a residuary subject, and we can say that it is on the residuary list. The residuary power essentially means that the Parliament has the power to make the laws on these residuary or remaining subjects. A simpler illustration could be something like this. If a pile of coins is separated by value, then the gold coins are taken by the center, the silver coins are taken by the state, and the copper coins are divided between the two. The tin coins are left over. These are the residue. These are not so precious, but they are still coins. And here, the Parliament has the residuary powers to take them for itself. In the 1963 State of West Bengal versus Union of India case, the court reconfirmed the concept of residuary powers by ruling that the Union, that is the Parliament, had the authority to legislate on a matter that is not explicitly covered by any of the three lists, which in this case was the subject of nationalization of industries, which is not specifically mentioned in any of the three lists. Therefore, it becomes a residuary subject, and the Parliament can legislate on the subject. In the Indian legal context, the word repugnant indicates a conflict or a contradiction or an inconsistency between two laws or two provisions. The word repugnant is also used in Article 254 of the Indian Constitution, from where this doctrine or principle of repugnancy actually comes from. This article says that if there is a contradiction or a conflict between a law made by the state legislature and a law made by the Parliament, this is a situation of repugnancy. In such a situation, the law made by the Parliament will supersede or prevail over the state law, up to the extent of the repugnancy. If only a part of the laws or some provisions are repugnant, then the central law will override the state law only to the extent of those repugnant parts. But if there is a complete repugnancy between the two laws, that is, there is a complete contradiction or a complete conflict, then the central law will fully override the state law. There is also an exception given in clause 2 of the article, which says that the state law can prevail over the central law on the concurrent list subject if it has been reserved for consideration and receives the assent of the President. This exception again has another exception, that even if the state law has prevailed over the central law thanks to a presidential assent, it does not prevent the Parliament from passing another law on the same subject that adds to, amends, varies, or completely repeals the state law. The principle of repugnancy was confirmed by the Supreme Court in the M. Karunanidhi versus Union of India case, where it held that if the provisions of a central act and a state act on a concurrent list subject are fully inconsistent and absolutely irreconcilable, then the central act will prevail and the state act will become void in view of the repugnancy. Since we have just discussed the concepts of occupied field and repugnancy, both of them appear to be similar. So, what is the difference between these two? I can explain it like this. Both occupied field and repugnancy affect laws on concurrent list subjects, where both the center and the state have the competency to make laws. In an occupied field situation, the center has already made a comprehensive law that occupies the complete scope of the subject. So, there is no more space left for the state law to occupy. So, the states should not make any laws on that subject, and even if they do so, such laws will be void. In a repugnancy situation, the center has made a law that occupies only a part of the available scope, and the state legislature has made a law that occupies another part of the scope. And there are some parts of both the laws where there is a contradiction or a conflict. Then the central law will prevail over the state law, to the extent of the contradiction or the conflict. This approach ensures that between the central law and the state laws, the complete scope of the subject is covered and only the contradiction is removed. Of course, due to the exception in clause 2 of Article 254, the state law can prevail over the central law if the President has considered the conflict and given assent for the state law to prevail. And the exception to clause 2 says that even if the state law has prevailed over the central law due to the presidential assent, the Parliament can just pass another law that adds to, amends, varies, or completely repeals the state law. So ultimately, the Parliament can supersede the state legislature. Plenary means unqualified or absolute. So plenary powers are referring to the unqualified and absolute powers of the Parliament in certain situations on certain subject matters. The concept of plenary powers is not actually mentioned anywhere in the Constitution. It is actually based on the various judicial interpretations of the Constitution in various landmark cases like the Kesavananda Bharati case. Normally, the Parliament can make laws on the subjects in the central list, and the states can legislate on the subjects in the state list, and both can legislate on the subjects in the concurrent list. But in certain situations, such as a national security requirement or a defense requirement or due to an international relations requirement or in an emergency situation, the Parliament has the absolute and unqualified power to legislate on any and all subjects on any lists. Of course, thanks to the concept of checks and balances, the courts can still assess if the Parliament's actions are unreasonable, disproportionate, or arbitrary, and the courts can still strike down the actions of the Parliament if required. In the Kesavananda Bharati case, the Parliament sought to amend the Constitution using the powers granted by Article 368. The court ruled that while the Parliament does have the power to amend any part of the Constitution, even with such absolute or plenary powers, the Parliament cannot alter the basic structure of the Constitution. So, even plenary powers have some limits. I have previously explained the doctrine of eclipse in my series on constitutional law. It is actually a very simple doctrine and concept which can be understood by looking at this picture. What happens when there is a solar eclipse? Well, the moon comes between the sun and the earth and eclipses or obscures the sun. So you cannot see the sun from the earth. The sun does not go anywhere. It is still there. It is just not visible. And when the moon moves away, the eclipse is removed and the sun will become visible again. In the context of constitutional laws, the doctrine of eclipse applies to pre-constitutional laws. That is, laws that were enacted by the British government in India, and also on laws that were enacted by the Indian government after independence, but before the Constitution came into effect in 1950. In The Bhikaji Narayan Dhakras versus the state of Madhya Pradesh case. There was an old law from 1947 which allowed the state government to create a monopoly for itself in the motor transport business and exclude all private operators from such a business. When the Supreme Court decided on this case, it applied the doctrine of eclipse on the old 1947 Act. The court held that the 1947 Act, which was a pre-constitutional law, became void after the commencement of the Constitution in 1950 because the old Act violated Article 19(1)(g), that is, the right to practice any profession or carry on any occupation, trade or business. Because of the doctrine of eclipse, that part of the law which violated the fundamental rights became inoperative, which meant that the government could not create a monopoly for itself by preventing private citizens from carrying on motor transport businesses. But the old law did not disappear completely. It only became invisible or inoperative, and that too only to the extent where it went against the fundamental rights. The other parts of the Act, which were not contravening any fundamental rights, continued to operate as usual. Later on, in 1951, in the First Amendment of the Constitution, the fundamental right under Article 19(1)(g) was amended with a qualifier that nothing could prevent the government from engaging in any trade, business, industry or service and create a monopoly for itself, which meant that the eclipse was removed and the old law, which allowed the government to create a monopoly for itself in the transport business, was revived and it became enforceable again. To sever means to cut out or to separate. The doctrine of severability or separability is a very simple concept. If there is an enacted law, part of which violates any fundamental rights, then the court will try to apply this doctrine of severability on that law. If the specific part of the law that conflicts with the fundamental rights can be clearly identified, and the conflicting part can be cut out or separated or severed from the rest of the law, and if the remaining part of the law can still function without the separated part, then the remaining part of the law will continue to be valid. Only the separated part will be deemed unconstitutional and void. The basic rules here are that this doctrine will apply to partially unconstitutional laws only. If a law is mostly unconstitutional, then there is no point in trying to sever or to separate anything. The courts will assess the independence and the interdependence of the provisions to assess the severability of the conflicting parts. And only those provisions which do not affect the main purposes and the actual functioning of the law are severable. Otherwise, it will lead to a meaningless situation where the key parts of the law are severed and the inconsequential or the less important parts of the law remain effective. The idea behind this doctrine of severability is to prevent an entire law from becoming invalid just because of some conflicting provisions. It also prevents a so-called legislative vacuum, which is a situation of no law governing a specific subject, because the entire law that governed the subject has been deemed invalid because of some conflicting parts. In the A.K. Gopalan versus State of Madras case, the court used this doctrine of severability to decide that just because one part of the Preventive Detention Act violated Article 14 of the Constitution, the entire law is not invalid. Only the offending part can be severed and the rest of the law will remain valid. A nexus means a connection or a series of connections that link two things. So, territorial nexus refers to the things or the aspects that link a person, an action, a transaction or a situation with the territory of India. Why is this relevant? Well, normally Indian laws will be applicable within the territory of India. By applying the principle of territorial nexus, in certain cases, Indian laws may be applicable outside Indian territory as well. The doctrine of territorial nexus is supported by Clause 2 of Article 245 as well. While Clause 1 says that the Parliament can make laws that will operate on all parts of the country, Clause 2 states that a law made by the Parliament will not become invalid just because it may have extraterritorial operation, that is, it operates outside India. An example of this doctrine of territorial nexus in action can be seen in the Bharatiya Nyaya Second Sanhita, in which there are provisions as to how and when the Act will be applicable outside Indian territory, such as when an offence is committed by an Indian citizen either in India or outside Indian territory. The nexus or the connection here with Indian territory is the citizenship of the offender, or when an offence is committed by any person, whether the person is an Indian citizen or a foreign citizen, but the offence is committed on a ship or an aircraft registered in India, wherever it may be. Here, the nexus is the registration of the ship or the aircraft as an Indian vessel. Or when any person outside the territory of India commits an offence targeting a computer resource which is located in India. And here, the nexus is that the computer resource is in Indian territory. So, these are some examples of territorial nexus. Since the preamble is a very important part of the Indian Constitution, the interpretation of the preamble is also included in the interpretation of statute syllabus. But we don't need to cover this in depth. And also, whatever I'm discussing here today is already covered in the constitutional law series. First of all, an interesting fact about the preamble is that though it is at the beginning of the Constitution, it was adopted after the rest of the Constitution was drafted. One of the first questions that arose about the preamble was whether it is a part of the Constitution or not. In the Berubari Union case in 1960, the Supreme Court held that the preamble is not a part of the Constitution as such, so it is not so important. Later, in the Kesavananda Bharati case in 1973, the court reversed its view and held that the preamble is as much a part of the Constitution as any other provision or article. The Constitution is the supreme law and the supreme rule book of the country. So, can the Constitution be amended? Of course, the Constitution can and should be amended because it is a living document which has to change and adapt to the social, economic, cultural, political and technological changes in the Indian society. And so far, the Constitution has actually been amended more than 100 times. But if the Constitution defines what India is as a country, the basic idea about what we are, can the Constitution be changed indiscriminately? Well, the answer here is no. There are some limits to the changes that can be made to the Constitution. In the Kesavananda Bharati case, the court held that the objectives mentioned in the preamble are part of the basic structure of the Constitution and may not be amended, which means that the Constitution can be amended, yes, but no amendments can be made to remove the objectives mentioned in the preamble. For example, the preamble mentions that we are a democratic republic and no government or parliament can change it to say that we will now be a communist republic. And the fundamental features of justice, liberty, equality and fraternity that are mentioned in the preamble are sacrosanct, and all statutes, laws, rules and guidelines in the country must adhere to these fundamental features. And also, the actions of the government and the citizens must not contravene these basic requirements. These basic requirements have been called the basic structure of the Constitution, and the basic structure doctrine just means that the Parliament can amend any part of the Constitution, but the basic structure must not be altered. So, does it mean that the preamble cannot be altered at all? Well, it can be altered, and it has actually been altered at least once so far, in 1976. This was when the words socialist and secular were added here, and the word integrity was added here. So, if the preamble is a part of the basic structure, and the basic structure cannot be changed, then how come these changes in 1976 were not challenged? Well, I believe that it was because these changes are not negative. That is, they do not take away anything from the existing basic structure, but they only add more clarity to it. So, these changes were probably never challenged. And with that, we have come to the end of this video. If you have any questions or feedback, post a comment below. Thanks in advance for your like, share and subscription. I will see you again in the next part of this series. Take care and Jai Hind.